Greeting to everybody. I, Kumari Akancharai, going to present a topic which has been allotted to me in the subject, the statutes interpretation or the interpretation of statutes. That is doctrine of Ejusdem generis. Very important for the interpretation of statutes to finding out the meaning of a provision or statute or law, whatever you can say. This doctrine is a part and parcel of secondary rule under the interpretation of a statute. So moving forward, I would like to present firstly the meaning and definition of this doctrine, that is Ejusdem generis. Ejusdem generis is a Latin term and the meaning of it is the same kind and of same nature. So in this line only you can relate that there is a nature already decided, there is a kind already decided. So same kind of that already decided. That already decided is nothing but the list, but the genus, the class, the category. So when we are deciding a word, a single word in relation to other word which has been already decided, which that word is of same kind, of same nature, which is already mentioned, that would be counted as then the principle of Ejusdem generis could be applied. Blacklaw Dictionary says the principle of Ejusdem generis is where general words follow an enumeration of person or things by particular and specific words. Not only these general words are construed but also held as applying only to person and things of same general kind as those specifically enumerated. So in relation to that specifically enumerated list or word, we have to find a same nature or same kind in relation to that single word. Doctrine of Ejusdem generis provide a specific list of word of the same nature, same kind, and we interpret that question work, that impugn word in light of that list only. Where a law lists specific classes of persons or things and then refer them to general, the general statement only apply to the same kind of persons or thing specifically listed. So when there is a list of a specific class of persons or thing and then refers it them in general, the general statement only apply to the same kind of person or specifically mentioned into that list. Before moving forward, I would like to, everybody must be knowing that Article 12 of Indian Constitution, which is very important, which is defining a state. So when you will go through that article, you will find that what is the state. So in that article it is mentioned that Government of India, Parliament of India, Government of States, Legislature of the states, local authority and other authority. So above 5 is very much clear, but last one, that is other authority. That other authority is questionable, which is providing a wide range of scope for the judiciary to interpret the institutes, the things in the light of that already above mentioned 5 instrumentalities. So the other authority is interpreted in light of already mentioned list, or that other authority is widening the scope of state. So similarly, in the case of Evans versus Cross in 1938, the term other device was in question mark. The impugned word, whose meaning was not clear, judiciary applied the principle of Ejusdem generis and find it out into the act that whether any exhaustive list is present to define, and so that we can interpret that other device in light of that present list. What we found that in that case, the device were mentioned, that signal, warning, signpost, sign or other devices. That other devices was about to be interpreted, and question was painted line, whether painted line would be counted as other device into other device or not. Court had applied its mind wisdom and said that no, because other device, as the court was interpreting, that is based on the list, and that list was exhaustive, which was including something. So court had to interpret that other device term in light of already present those terminologies. Hence court rejected the contention and did not apply the after applying the rule of Ejusdem generis, did not accepted the contention raised by the party. What is the need of doctrine of Ejusdem generis? Doctrine of Ejusdem generis is very needful, very important, not only for the finding out the meaning, but for the widening the scope to providing opportunity to judiciary to act for the better meaning and to find out the intention of legislature behind incorporating that word or a statute into the law. So the first need is the interpretation of a statute by doctrine of Ejusdem generis arises that when there is an ambiguity, unclearance, absurdity into the provision, that can be cleared by the help of rule of Ejusdem generis. If there is a possibility of two meaning, that meaning which is very relevant and which is suited to the notion of the legislative intent, that would apply. So it could also be find out by applying the rule of Ejusdem generis. Meaning of a provision which is defective or which is not fulfilling the purpose of the statute, so also the Ejusdem generis rule could be applied to find out the true meaning so that the purpose of a statute could be served. Next is there is no need for interpretation if the language there is no ambiguity and no clearness. I have already said and I am saying that when there is a requirement that this word's proper meaning is not coming out of that because literal and grammatical interpretation, golden rule, mischief rule is getting failed to providing the true meaning of that word, then only this rule of Ejusdem generis, any secondary rule, would apply. When it apply, in Lilavati Bai versus State of Bombay, Supreme Court has observed that where the context and the object and mischief of enactment do not require restricted meaning to be attached to the words of general importance, the court must give those words their plain and ordinary meaning. Now, court will provide the plain and ordinary meaning if it is possible to construe as per the literal and grammatical interpretation of that statute. So, meaning thereby application of rule of Ejusdem generis is very specific, depend on existence of certain circumstances only. Second thing, but when on reading it is found that there is some ambiguity in the provisions of the statute and the intent of a statute is to restrict the general word to the category of a specific word, then this doctrine of Ejusdem generis is applied. So there must be a list of general word and that general word is helpful to reach towards the proper and true meaning of a given or impugned word or sentence or provision. Therefore, general word follow the specific word and those specific words have a genus and category which they belong. Ejusdem generis is considered as a facet of nociter a socies. Nociter a socies is another secondary rule of interpretation, which means nociter means to know, associate means in association with. Know the meaning of a word or a sentence in association with. Many a times being in isolation would not clear the meaning of that word, but when that word come with a group or a kind of list, exhaustive list or genus or already established or associated words, the meaning became clear. So nociter associates is the broader terminology and one of that terminology's facet is Ejusdem generis. It has been considered in landmark judgment of Maharashtra University of Health and other versus Shikha, Paraskar, Mandal and others 2010. Next case was of Viscount Simons in Attorney General versus Prince of Amist Augusta of Hanover. That was a very leading case in which the same thing was said that a specific word sometime lack on providing proper meaning because it is in isolation, but when you are considering that word in light of already general terminology, then meaning become much more clear. So moving forward, that essentials of doctrine of Ejusdem generis. What is the essentials? Why we need it? So in case of Amar Chandra Chakravarti versus Collector of Excise 1972, Supreme Court given certain elements which is very, very important for the application of doctrine of Ejusdem generis. First one, a statute contains an enumeration of specific words. The subject of enumeration constitute a class or category. That class or category is not exhausted by the enumeration because there is a scope of incorporation of many other terminologies. There is no indication of different legislative intent. I had already quoted that two things is very important in doctrine of Ejusdem generis. First thing, that this impugned word or questionable word must belong to a class, category or genus. Second thing, that when you are interpreting that word, you have to be focused on the legislative intent, that what legislature's objective notion behind formulation or incorporation of that word into the provision. So you can't ignore that. I had already covered the class or genus and the legislative intent behind putting that specific word. So you can't go beyond that. If you are going beyond that, then it would not be counted as a valid interpretation of a statute, and in appeal, in fact, your interpretation would be rejected. So landmark judgments is of 1989, which is Siddheshwari cotton mill. In that case, any other process was about to be interpreted. That any other process was interpreted by Supreme Court in light of already mentioned terminologies, which are as bleaching, mercifying, dyeing, printing, waterproofing, rubberizing, shrink proofing, organic processing. So all these listed terminologies were helping tool to find out what can other process be, so that we can reach to the conclusion. Next, I would move that what are the limitations in application of doctrine of Ejusdem generis. Doctrine of Ejusdem generis can't be applied generally. There is a specific word, there can't be a specific, there is a specific application of that doctrine. General words are there before the specific words, then this doctrine can't be applied. Therefore, it is necessary that specific words must be followed by the general word. Very important. That was held in Department of Customs versus Sharda Gandhi 2019 Supreme Court. Next, it was decided into the case of 1964 Jagdish Chandra Gupta versus Kajaria Traders. Court held that whenever the specific words are being followed by general word, the interpretation of Ejusdem generis does not need to be applied. Very important, as I already quoted. So as also the doctrine of Ejusdem generis can't be applied if the general word follow the only single word, that single word. So a specific word must follow the general term, but that should not belong to any single group. That group I am quoting wrong, but that word should not be in isolation, right? Next I have is that there is a permissible limit for the judiciary to apply this doctrine. You can't use it generally. If there is a possibility to find out the meaning via applying primary rules of interpretation, then do not jump into the secondary rules. It is the basic principle of applying interpretation. Now, improper use of Ejusdem generis doctrine would lead towards the miscarriage of justice. And if you are doing so, then you are not providing justice up to the mark. So, as we have been said to provide the latest judgment, I had already provided judgment of 2019, that is Department of Customs versus Sharda Gandhi 2019. Next, I am going to present in front of you that is Kailash Chandra versus State of Orissa judgment, that is of 2022. Counsel for the petitioner submitted that the impugned order passed in a petition for condonation of delay is clearly covered by the phrase other proceeding. That term other proceeding was about to be interpreted into that matter in the light of section 115 of the Code of Civil Procedure 1908, and it was interpreted by applying the concept of Ejusdem generis. Next was of Union of India versus Manraj Enterprises 2021 case, in which the court firstly observed that rule of Ejusdem generis guide us that where two or more words or phrase which are susceptible of analogous meaning are copied together, they are to be understood to mean in their cognate sense and take color from each other, but only if there is a distinct genus or category. Very importantly, we have already seen into the Nocite Socialist maxim also that how the single word take color from the already established list or genus. Similarly, because we know that Ejusdem generis is one of the facets of Nocite Socialist, so court was of opinion, Supreme Court was of opinion, and in first point it has observed so. Secondly, the court noted that the rule of ejusdem generis is applicable when particular words pertaining to a clause, category or genus are followed by general word. In that precedent, Supreme Court had established the theoretical facts into the precedental facts. Thirdly, court warned that the rule of ejusdem generis has to be applied with a care and caution. It is not an inviolable rule of law, but it is only permissible inference in the absence of an indication to the contrary. Fourthly, the court noted that if a narrow construction happens on the basis of ejusdem generis, and such narrow construction or interpretation seems aligned to the intention of the parliament. So if you are going with the narrow construction also, you have to be focused on the intention of parliament, that what was the reason, what was the intention, objective of the parliament behind putting that word into the legislation. Next case is Principal Secretary, Department of Labor versus Om Dayal Education and Research Society 2019, in which Supreme Court has said that counsel on behalf of respondent writ petitioners submit that section 1(4) of the act primarily applies to the factories as their amending act of 1989. So word establishment was interpreted into the matter, or the word establishment in light of education institute it was interpreted. So court applied the doctrine of ejusdem generis and said that the rule of ejusdem generis operate only to give a rebuttable presumption that the words of statute are restricted in application to a certain genus of thing, because the statute is not able to exhaustively provide it all the elements that would conveniently fall within that genus, can't contradict legislative intent, and must either give away to the purposive interpretation. So very important observation was made by the Calcutta High Court into that matter, and it said that application of ejusdem generis rule is not general. You can't rebut or you can't contradict the intention of legislature. You have to be bound by already existing list or the word. So you have to interpret the impugned word into the light of all those decided words. Court had cleared it. Next case is Brijesh Gupta versus SMT Saroj Gupta, which is of 2022, which says that ejusdem generis concept applies when a specialized terms complement a general word. Similar contention, because theoretically the concept of ejusdem generis is very clear. In those cases Supreme Court applied that and interpreted the different terminologies in light of already specified list and reached to the conclusion. So we can say that the concept of ejusdem generis or the rule of ejusdem generis is old, but it is gold, because it is into the line also. It is applicable as courts are applying this concept to interpret the words or the lines or the statutes or the laws. So conclusively, I would conclude here by saying that doctrine is a part and parcel of a statute or interpretation of statutes, and there are certain rules to interpret the statute or law. Primary and secondary rule. Doctrine of ejusdem generis is belonging from the secondary rule. It has to be used very cautiously, because miscarriage can happen anytime. So miscarriage of justice is the drastic or tyrannical step. So court should be very cautious while applying the concept of ejusdem generis. So this is the brief detail about the concept of ejusdem generis, its application, where it should not be applied, its limitation, as well as the recent court's judgment either of High Court and Supreme Court, which is belonging to 2019, 2022, 2021, 2023. So very important these landmark judgments are. Thank you so much. I hope that this would be informative and more what we can say that entertaining too. Thank you.